And good morning and a happy new year to everybody. I think everybody is in the new year as far as I know. If you're not, that would be really interesting if somebody out here is not in the new year. If you're not in the new year, then let me know. And I'm not just talking about like metaphysically speaking. If somehow it's still 2025 where you are, that would be very interesting. Good morning, afternoon, whatever. Hope everybody is well. We're going to talk a little GTII today. And before I go on, I might as well just shout it out from the beginning. And I'll do it at the end also. So, Renee and others are leading a group involving, I think it's called like the GTII Resolution Group. They're raising money to hire counsel. I think they've made a lot of progress and they're near the end of their time period where they need to raise the funds. So if you're interested in that, please reach out to Renee or anybody else associated with the GTII Resolution Group and do it quickly. You're not obligated, of course, but if you're interested in helping out and looking out for the interest of GTII shareholders like yourself, please reach out to them and explore that and do it soon. So, said that, starting in about 2 weeks, I'm starting whatever this means, a semi-daily show called Not the News, KNOT, of course. Tentatively, it will be at 3:30 p.m. Eastern, and it'll be my take on the news in a daily fashion. We'll see how that goes. I welcome you to watch. Please like and subscribe. Obviously, this is not legal advice, but this will be I think this is going to be an interesting particular live stream today. Yeah, like, subscribe, share, comment, whatever else applies. I've mentioned Renee. Along with Renee, I've had an interest in expressing myself to the court as a GTI shareholder. I have attended some hearings. I've been at all the depositions, at least on Zoom. So I've spent a good amount of time attending. But there was a hearing early, and I'm theoretically a plaintiff, but I'm not represented by plaintiff's counsel because I sought my release from plaintiff's counsel because I then could use my own voice and attend things, etc. There's a benefit to me being kind of out here. I can participate. But there was a hearing, and at the hearing, it's probably about 3 or 4 months ago already, maybe more, it appeared that I could not speak. And of course, if the court asked me to speak, I could speak. But otherwise, unlike the other attorneys who are actually actively involved in the case, I'm not appearing as an attorney. I'm appearing as a shareholder, and I can't speak. So that limits what I can do. But one thing I wanted to do is, and I've been talking about this for quite some time ad nauseum, was to submit a pleading to the court and let certain issues be known. And there's a hearing on January 14th, 2026. That relates, I think, to Renee also and the counsel they're seeking to hire. I think they're hoping that their counsel will participate in that hearing also. Although I don't think the counsel has currently not been engaged, and I can't speak. So it'd be nice if somebody else was there that could speak on behalf of shareholders. But what I did is I submitted a brief to the court, a declaration for myself, which I will read because it's not too long, that kind of discuss certain issues that I've raised that I think need to be discussed at this time. There may be other issues that need to be discussed at a later time, but I wanted to deal with what was going on. So my view, and I know the court has said this, I think they read all the briefs. So I've submitted this. I presume that the court will read it. And even if I cannot comment, I think I've raised some issues that I've talked about for quite some time, and we'll go from there. So what I'm going to do is just going to read. I'm going to read my little declaration, which is like 4 or 5 pages. So it's not long. It'll go fast. I'll read fast, and I'll start with. I'll ignore the first page and that stuff. I'll just kind of talk about the substance. And this was filed yesterday in the court. Court accepted it, so it's in the court file if you're looking for it. I, Richard Hoffman, present this declaration with regard to some of the issues likely to be addressed at the 1/14/26 status conference requested by the Receivers Council. The following facts are true and correct, and based on my own personal knowledge, except as stated otherwise. Stop. The status conference was requested by Receivers Council. I think it was at the last hearing when there was a hearing on the disqualification of the attorney. I think during that hearing or at the end, Dylan asked for a status conference, which is going to be the afternoon of 1/14/26. I'm going to certainly try to attend in some fashion, but that's what it's referring to. Next, I'm an experienced investor and an owner of approximately 20,000 shares of GTII. I first became a GTI shareholder in or about the second half of 2023. Since extremely late 2023, I began to monitor the activities of GTI closely. I communicated with their then counsel and sent numerous communications to senior management requesting information. In the past, I also communicated with the receiver. Next, in my opinion, the receiver, and in particular the receiver's litigation counsel, have done a good job in many respects. However, there are two issues likely to come up at the 1/14/26 status conference that I've raised to the Receivers Council that appear to require further examination. Then I get into that. When the receiver was appointed in September 2024, the order entered by the court appointing the receiver suggested, and then I reference the page, line, etc., that to the court's understanding that as of September 2024, more than 16 months ago, the receiver would take, and these are the important language that I claim the order says, immediate corrective action on the regulatory issues and filing. Some 16 months later, and despite the use of the term immediate, I'm not aware of any material regulatory corrective action having occurred nor even being disclosed. Okay, so I'm going to stop there. Now I'm going to go to the order because I'm claiming something that order of September of 2024 said something, and at least we could look at that order, and I'll read it to you, and you decide if what I said, that the order said that they were about to take immediate, or the court understood that they were going to take immediate corrective action. Let's see what the order says on that. Paragraph 21, page 7 of the order. Finally, the court finds that the receiver requested by plaintiffs, Paul L. Strickland, is competent and well situated to serve as equity receiver of GTII. The court notes that Mr. Strickland is ready and prepared to take immediate corrective action with respect to GTI's delinquent OTC and SEC filings. So I feel comfortable that the order and my declaration are consistent with each other. And that order was entered in September of 2024. We're now in 2026, just to kind of keep it. If anybody out there is aware of any corrective action that was disclosed, I'd be interested in that. I don't see how corrective action could be undertaken before an audit had been completed. So let me just continue with my declaration. Moreover, the audit on this zero revenue company, which in its multiple reports the receiver indicates is ongoing, and then in parentheses I indicate, and likely required to undertake any corrective action. In other words, you need the audit to do the corrective action, still has not been completed. I've asked the receiver, and this is important because I sent several emails, and this is how it is. I've asked the receiver to provide some representative from the auditor to attend the 1/14/26 status conference and explain what is going on. I've not heard back from the Receivers Council in the affirmative as of this date. In other words, they haven't said they're bringing anybody. To date, next paragraph. To date, especially in light of the language of the September 24th order, which I read to you, the receiver has not provided any meaningful reason that the audit, let alone corrective action, has not been undertaken. The slow pace certainly cannot help the chances of consummating the previously disclosed AI Versity transaction or any other deal. Next paragraph. The Receivers Council has also seemingly suggested that the reason it cannot provide more specificity to any release date is due to concerns as to how those trading the stock might use that information. However, almost all the shareholders who own stock cannot trade it as it is in the expert markets. Moreover, I have previously requested that the receiver try and stop any trading of the stock. At best, they suggested it cannot be done, but have provided no basis for that conclusion. Perhaps there are valid reasons for whatever the receiver is doing as to this issue. There certainly has not been sufficient transparency to already harmed shareholders. And by the way, me asking about, give us an update about the timing of the audit. I'm not asking for the substance. So, perhaps the argument would be better if I said, tell me what the audit said, because maybe knowing the information might be meaningful. It'd be like if you watch the movie Trading Places with Eddie Murphy, which I love, by the way. They got I think it was the orange reports, whether it was going to be a good year or a bad year. And that was hugely significant. This is slightly different. I'm just asking for a timing of when this is going to be done. And here I've asked that they produce somebody to explain what's going on, to put it in context. Okay, going on. To provide further context, GTII's prior auditor, Borgers, was terminated by the SEC for ridiculous and pervasive misconduct. Because of that, and because of a failure to accurately keep financial records, an audit was needed. And I in parentheses, I think it was for 2023 and 2024. And I guess 2025 we'll have to see, although I don't know what they've done in 2025. Inexcusably, the receiver elected to first use the auditor prior management, who the receiver had accused of misconduct, to replace Borgers, who had been terminated by the SEC. So after Borgers got terminated, prior management, including Reichman, et cetera, chose a particular auditor to continue with the work and do audits. The receiver came in and used that same auditor that prior management had chosen, even though there were accusations and reports later that prior management had engaged in misconduct. So I'm continuing. That ended up choosing keeping the same auditor. That ended up being a disaster, necessitating the receiver terminating that auditor. I believe Fortune was the name, and wasting essential time. Then the receiver hired another firm. As of the date of this declaration, and it was filed on December 31st, no audit has been completed and no firm date has been provided more than 16 months after we understood it would be completed in short order. Where seemingly only select brokers and some outside the U.S. can trade the stock, it makes no sense to withhold clarity on the delay of the audit. Without a completed audit, GTI will never trade again and shareholders will lose everything. For a company with no revenue, the time frames for delivering audit information have been unreasonable and obscure. My inquiries were not about the contents, but the unexcused delays. That's kind of my pitch on the audit and the corrective filings and having somebody be there. Now, again, I can't discuss that, or unless the judge wants me to discuss it, I can't discuss it on the 14th. If he wants my input, then great. But other counsel will. The court probably will have seen it. I presume that Mr. Siciliano probably will see this and will comment on it. If Renee's group ends up with counsel, and even if they haven't filed anything, they would be able to comment on the issues that are raised. So I expect at least the issue of the audit and the status of the filings to be discussed. And I've put it, as a shareholder, I've put it before the court. The second half of my short declaration, I don't know how you make a short declaration longer, just keep on babbling on. Second part of my short declaration is the receiver's compensation. And I'm going to go on. This is the shorter part. Not yet at issue, although seemingly addressed by the receiver in his fifth interim report. So I thought it might be a topic at the 11426 status conference. and I'm going to stop there to clarify. The fifth interim report, there was a section where, and again, I didn't think it was appropriate, but whatever, that the receiver seemed to defend his compensation. So since he defended his compensation in the fifth interim report, and since he hasn't put out a new report, and since the status conference is after the last report, it may be addressed. And so that's why I'm bringing it up here. I'm not going to linger on it, but I brought it up. The compensation agreement entered into between plaintiff's counsel and the receiver is unreasonable and clearly not specific enough. And I'm not challenging, I'm not going to go into detail about the reasonableness because there's compensation, there's not a motion for compensation at this particular hearing, but I wanted to lay it out so it's not claimed to be a secret, even though I've raised it and bitched about it for quite some time. For example, I'm reading back from my declaration. For example, without getting into the issue of whether in effect the compensation package provided to the receiver is reasonable, even if the package were deemed reasonable, the package failed to address essential points such as when the receiver could sell any of his shares. It would appear to be patently or pushily unfair if the receiver were permitted to sell his shares before any locked out shareholders could, which is the vast majority of shareholders. Next paragraph, there are no current restrictions as to when the receiver may sell his stock. Per his existing pay package, he could obtain more than 15 million shares of a reduced float GTII stock, making him the largest shareholder. First, that could unfairly and completely dilute the interests of real shareholders. Moreover, with no restrictions on when he could sell his shares, the receiver would be in a position to sell his shares before other non-insider shareholders could. Additionally, by selling huge blocks of shares, that would further depress the price that normal shareholders could get on their future stock sales. This all seems unfair and one-sided. New paragraph. Additionally, when the compensation deal was struck between plaintiff's counsel and the receiver, shareholders were not aware of the extent of the hidden disputed shares. At or about that time, about 36 million of questionable of an approximate 60 million shares had just been canceled. And that 36 million were, I guess it was claimed that they had been issued in error. So 30 million remained. Thus, everyone thought that the number of shares at issue were the remaining 30 million shares or so, not the approximate 180 million that apparently turned out. And then I signed it under penalty of perjury and filed it. So what I've raised are the issues of the audit, the corrective filings, and the compensation. And I think those will be addressed at the status conference. If new counsel is brought in and they concur, and my guess is they're going to concur about certain elements of this, I'm sure they will have the opportunity to discuss it. And I hope that a representative of the auditors is there, or if the audit's completed, what might happen is, I've been bitching about the audit for months. And if in fact, there's two ways I think of dealing with this, because otherwise, I don't know why you wouldn't have a representative there just to give a pitch. But the other way is to have the audit done. So perhaps before the 14th, we will have a completed audit. That's kind of my hope. And by making it an issue, I think that encourages that to be done. So we shall see. We shall see, and anybody who's an attorney of record in the case, including anybody that Renee's group gets, will be able to comment about the contents of this declaration. And again, if the court calls on me, then I will comment about what I wrote in there. So that's that. Next, there was and I've referenced it. I'm not going to say which one, but there's rules for lawyers, and it may and they may comply not for the best reasons, but there's a rule for there's lawyers, and part of those rules are, and most states have it. California has it, very specific. Nevada has it. I think a lot of states have it. So if you're involved in some proceeding with another lawyer, even if that lawyer is not from your jurisdiction, and that lawyer provides evidence that they were engaged in criminal misconduct, or there is substantial evidence of that, then under the rules of the various bars, you have a affirmative, you being any lawyer involved has an affirmative obligation to report that to a bar or any other jurisdiction that could take action as to that. So it's a very serious thing, but it's a mandatory requirement. And what would happen is if you were in some kind of proceeding and somebody said something that equated that they were involved in criminal conduct, and there was multiple lawyers there and only one reported it, then the non-reporting lawyers would get in trouble for that. So there's an affirmative obligation on all lawyers to report it. And in one of the depositions that has happened and also the rule is you can't threaten to file like a bar complaint or to go to a DA or DOJ or FBI or anything like that. You can't threaten it because you can't threaten criminal or administrative proceedings to gain an advantage in a civil case. But you can do it. You can actually do what you're required to do. And there was, and I can say this because I'm personally familiar with it. There was a proceeding that has happened, and it involved lawyers and multiple. My understanding is that there's been multiple filings related to testimony that was given at one of the depositions. And I think everybody at that deposition who was counsel, just in my opinion, has an obligation to report it. I know it's been reported. That I'm certain has been reported. That's already been done. But I don't know if all counsel has reported it, including the counsel who may have been situated on another side. And that's even whether you said anything. It's just if you become aware of it. I guess if you read a transcript, you might have to also. So if you were, probably do. So it probably applies to all counsel. If they read the transcript of that particular deposition, they would have to report it. And I had been, talking about the fact that, and this is long ago, we haven't got to that point, but, in some of these depositions, as the parties that were involved, I didn't see how those guys would testify without taking the fifth. I know that certainly I would have, for certain of these people, if they were my clients and they were asked to be deposed, and I found out that there may be questionable conduct, but that might be misconstrued, or argued to be criminal, I would not let them testify. I let them take the fifth. That's absolutely what I would do. And I've been expecting this all along. And the fact that somebody testified and didn't do that, and the testimony forced all counsel there to report. It was clear as day. And that's not my sole. I'm not the only one with that conclusion, just so we're clear. So that's done. And how that turns out, I don't know. I would expect there to be ramifications, but I don't know. And I would expect that those ramifications might go beyond just that particular person. And I mean, beyond the lawyers too. I think it may, because if you describe certain conduct and it involves other people, those other people might be implicated also. So I think this might, implicate a lot of people. And again, it's because the person either got really bad advice or knew better than everybody else. But I think it was clearly unwise for that person to testify, and I don't think he's the only one who's going to be testifying. Again, the ramifications, if you engage in criminal misconduct, and and again, that's not for me to decide. I'm not a prosecutor, or not that, but I know others thought that perhaps the allegations amounted to that, or the testimony amounted to that. But we'll have to see how it's handled, and we're not obligated when we report to make a conclusion that the misconduct has happened. We indicate that we heard information that arguably could be construed as such. So it'll be interesting to see how that impacts others who might testify. And speaking about others who might testify, there was another attorney who had agreed to testify. And as a matter of fact, as I was told, he was gung-ho about testifying. And I think this attorney was going, and again, I've never spoken to him, so I don't know. I'm just purely speculating based upon some information I was given, but I don't know because I didn't see the guy. But apparently this attorney was going to implicate David Reichman in some misconduct. But then all of a sudden, at the last moment, he apparently kind of disappeared, didn't agree now to voluntarily appear, and now has been subpoenaed to testify. I don't know what the date of the deposition will be, but I certainly will attend. I don't know I don't know what this attorney knows. I don't know if he, what his involvement was, what he could say, what his concerns were. I don't know, if he'll testify without invoking any privilege. That I don't know either. But it was interesting that after the prior deposition, where I don't think it went very well for the witness, and it wasn't, I'm not talking sequentially, but the deposition didn't go well for the witness. It's interesting to me that this attorney seemed to kind of back off his agreement to testify voluntarily. So those are kind of the things that are going on. On 1/14 is the next date. I believe plaintiff's counsel is out of the country, so I don't believe, no, not plaintiff's counsel, the receiver's counsel is out of the country, so I don't believe anything substantial is going to occur before the 14th. But hopefully, I will certainly, if there's any new information, I'll report about it. I will appear and follow the hearing on the 14th of January, which is about 2 weeks away. Renee's group, the resolution group, is trying to put together people as a group to hire counsel, to have their voices heard. I think they're very close to their goal. So if you can help them out, please reach out to the GTII resolution group. If you look on X, they're there. There's people on the stream. If somebody could put Renee's information in this chat, if they have it, please do so. Anybody else who's connected to Ray, and if anybody sees anybody who's asking if they can contact that person and let them know. Of course, you're not obligated to, you don't have to, but it's a group that I believe has the interests of GTII shareholders at heart. And I don't think you're going to go wrong in that respect. But contact them and get more detail. I think there's a time deadline. That's why there's a push for that. Other than that, I'll keep you apprised over the next couple of weeks as things go on. If you want to catch my new Not the News, please feel to jump in. I might do like a one version of it just as a test version, but I'll be starting in the next couple of weeks. Please like, subscribe, share, comment, etc. Be well, everybody. Have a happy and healthy new year. I hope this year is the end of our kind of being stuck in GTII, and that's what I'm expecting. I'm hoping this, I'm expecting this is the end this year. I hope also to my friends and colleagues at MMTLP, I hope this is the year that we all get satisfaction with regard to MMTLP, the epitome, as I cited, the epitome of governmental intervention manipulating and screwing retail shareholders. And if you don't know the story of MMTLP, you should follow that. It's very instructive. There's lots of information on it, and it really is a gross action by various actors in government against retail shareholders, just to shut up retail and to, end a problem in any manner possible, even if it's not legitimately ended. And obviously with GTI, we get the same thing. Just think about this. All this is going on. It's public, right? Because I do videos and the court proceedings are public and whatever. And I personally know, the SEC knows about this. The FBI knows about this. Various other institutions. FINRA has to know about this, although I don't know about FINRA. But I'm sure there's other governmental bodies that know about this and know about GTII, MMTLP. This is not in the dark. This is an election so far. And I don't mean with an election, a voting election, but this is a choice for government not to act. And it's been to the detriment of retail shareholders. And we should just keep that in mind next time you're at the ballot box and you look down at the ballot, see who helped you and who didn't. And if this is important to you, keep that in mind. Anyway, I hope everybody well. Happy New Year. Be well. Take care. And we will talk soon. And look forward to it. Look forward to your comments.